I'm a California lawyer. I don't practice in any other state. So when I'm very specific, it's about California law.
Okay. And that's good. I guess a couple of lawyers on Spreecast, we should point out we're talking California law. That applies to me also. And we're having a general conversation. We're not actually trying to share any legal advice or legal opinions with anyone. Once again, we're talking to Donna Bader, An Appeal to Reason, just an outstanding must-read book for anyone trying cases here in the state of California. Donna, talking about common obstacles on appeal, at Chapter 2, you reference the first rule of the appellate procedure is you generally cannot raise an issue for the first time on appeal. Why is that important, and what advice do you have for trial attorneys with respect to making sure before they rest, before they close their case, making sure that they've raised that issue for appeal for, at the trial level? Do you have any advice, and how can we avoid making any mistakes concerning that particular issue?
Well, remember that an appeal is essentially a review. So if it's raised for the first time, it's not really a review. It's like a new argument. You have to bring in all your theories and your objections down below, and then the Court of Appeal reviews them. It's not as if it's like a second trial or a second bite at the apple. So you have to have it all down there. And boy, I just had a brain freeze.
Well, let me jump in real quick, because first of all, I want to say hi to Chris Russell, who's chatting below. Chris is getting up to speed on social media and online relationship building, and he's asked a question: how was it possible for a presiding justice to pen the King decision and then a shorter letter concur on the Howell decision? How does that affect her credibility, and actually does it really matter if a justice has credibility? I don't want to get into specifics if you're not comfortable with doing so, Donna.
Well, I see two questions there, one from a Eugene Lee that came earlier, and I'll respond to that probably in the order that it was given. Writs of mandate, let's say you have something like a 10% chance of success. They're usually not as expensive as an appeal because you're putting together all the paperwork. Often you don't have oral argument. It's almost like a law in motion proceeding in that way. It's very compact. You file it, and the court makes a decision, and sometimes they have a hearing. It's a very low chance of success, but sometimes you have to bring them if it's a statutory writ, and you can look into the code section for the procedure that you're following, and if it provides for writ relief, then that may be the only way you're going to get it reviewed. If it's a non-statutory writ, you have to show irreparable injury. And usually you'll find that like in discovery cases where there's a privilege involved, or something really bad will happen if the court it's like you can't unring the bell. You need the court to do something now and step in and stop the trial court from proceeding. So I'm not going to say, generally they are rejected. They have a low chance of success, but I'm not going to say that you should never bring them. Sometimes you have to bring them.
Pause it. I'm going to
Jackson, Spreecasting from the OC. I am very, very excited today to have one of the finest certified appellate specialists in the state of California with us today as my special guest. She also happens to be a personal friend of mine, and her name is Donna Bader. Donna, so glad to have you joining us today on Spreecast.
I'm very glad to be here.
We're going to talk about things that trial attorneys need to know in order to minimize their exposure on appeal or to completely avoid having their case get appealed by the other side. But before we do that, I want to share with some of our viewers a little bit more about you. And do I have your permission to do that?
Nothing too personal, but go ahead.
Donna's home telephone number is now. In all seriousness, it's a pleasure and a treat to have Donna here today. One of the reasons I am so keen on Donna's abilities and Donna's services as an appellate specialist is that over the years, Donna has literally helped my clients preserve millions and millions of dollars in trial verdicts that I've been able to achieve for them. In the appeal, during the appellate process, Donna has protected those verdicts and has allowed my clients to wrap up and conclude their cases in a fashion where they're happy with the results, and we've been able to protect their verdicts. And Donna, thank you for doing that. For those of you that don't know Donna, she's been practicing appellate law for more than 30 years in the state of California, and her practice is exclusively limited to civil appeals and writs with an emphasis on medical and legal malpractice and personal injury law. It's my understanding, Donna, that you've written over 350 appellate briefs and writ petitions, and that's saying something right there. That's a lot of years of practicing appellate law and writing, so I tip my hat to you, my friend. Donna is also the former editor-in-chief of Plaintiff Magazine, a publication that is distributed to over 5,000 Northern California lawyers, and it's my understanding that she's also the former editor-in-chief of Consumer Attorneys Association of Los Angeles, which puts out the monthly magazine called The Advocate. Donna also happens to be the author of my favorite how-to appellate book entitled An Appeal to Reason, and this is Donna's must-read book that I highly recommend everyone to get. It's the best appellate how-to book that I've ever seen with respect to something all trial lawyers need to read. So, Donna, I want to thank you for that. Welcome, Donna. It's good to see you today.
Thank you. I'm blushing.
And that's okay. And, you know, with video, blushing's not a bad thing. Everyone gets to see the face and the person behind all those winning appeals. So thanks for being with us today. Donna, before we get started, let me just, let me start off asking you the question, what is, if you can narrow it down, what's the most common problem or the most common issue you see trial attorneys make at the trial level that you're forced to deal with at the appellate level?
I think it's failing to object, and I think it goes back to when attorneys try their cases, they're not thinking about the appeal, they're thinking about the trial. They're thinking they're going to win, and they're focusing all their energies on that, but they have to think about somebody who's not in the room and what that person or the Court of Appeal is going to see, and they have to make all the proper steps, and usually the first one is objecting to evidence or documents or something, and making sure that's on the record.
Do you see this type of mistake happening more so in civil trials, criminal trials, or a combination of both?
Well, I really can't speak to criminal trials because I don't read the transcripts that much, but I see it an awful lot in civil cases, and sometimes you'll even talk to the trial attorney, and I'll ask, did you object? And the attorney will say, oh, I think I did, or I'm sure I did, and I read the transcript and it's just not there.
What are your thoughts with respect to, sometimes in the middle of a trial, I'll purposefully not object to a question, or I'll not object to a piece of evidence because it has more to do with my trial strategy as opposed to me being concerned with a question being asked or a piece of evidence coming into evidence or not being allowed into evidence. How do you balance an attorney's interest in placing that objection during trial with trial strategy and or compromising their ability to succeed on appeal?
Well, I think it is